2024. In such terms and conditions that the court deemed fit, the branch of the application as contained in the affidavit in support of the application. Here, the ruling the process examined the applicant and accordance of the letter addressed to me in respect of the proceedings of the second day of December 2024 before the assistant registrar of this court. When the matter first came up on the 18th day of November 2024, the court issued directives to the parties to file their submissions and adjourned the matter wherein at the next hearing the proposed sureties will be identified and the oral highlights of the submissions only will be made by the parties. At no point did the respondent indicate that intended to examine the applicant. The prayer to examine was therefore brought at the time when all parties filed all their affidavits and submissions. Considering that application is proceeded by way of affidavit evidence, and the respondent made a reply to the application, and the fact that the respondent did not indicate to the court at the earlier opportunity that he sought to cross-examine the applicant, the prayer cannot be allowed. With regard to the proceedings of the 2nd of December 2024, before the assistant registrar, I have instructed the registrar to receive the particulars of the sureties. It goes without saying that the particulars of the sureties were already on record, and the respondent had also already submitted his written objections to the same sureties by your written submissions and affidavits. Bearing in mind that the application must be disposed of within 30 days following the application, the directive of the land registrar was therefore only record and identify the sureties whose particulars were already on record. The overall discretion in the application rests with the judge, and I shall determine this application based on the written submission filed. I now move to determine the application in its merits while carefully considering the submission is filed by all parties. Where necessary, I shall refer to them in the course of consideration of the application. The law that governs bail in Uganda is contained in Article 23 6 of the Constitution, provides that where a person is arrested in respect of a criminal offense, he or she is entitled to apply for to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Bail therefore is granted at the discretion of the court, taking into account all the interests of the parties involved and the society as a whole. The court shall consider the following way of determining an application for bail. That is the gravity of the offense, the nature of the offense, antecedents of the applicant so far as they are known, the possibility of a substantial delay in the trial, the applicant's age, the physical and mental condition, the likelihood of the applicant to attend trial, the likelihood of the applicant to commit an offense while on bail, the likelihood of the applicant interfering with the witnesses. The court further considers the safety of the applicant, the community, and the complainants. It also considers whether the applicant has a fixed place of abode within the jurisdiction of the court, or whether the applicant is ordinarily resident outside of Uganda. The court further considers whether the applicant has substantial